So today, friends, we are looking at the condo offer to purchase and the condo listing contract. We're just going to look at the parts that are specific to condo offers and condo listings. So I'm not going to go over the whole offer to purchase contract or the whole listing contract. But again, just the pieces that are different and specific to the condo offer and the condo listing, based off the general offer to purchase and general listing contract. So they're identical except for these pieces. Okay. So before we begin, any questions I can answer? We can answer before we get going. See who's all on here. Love it. All right, we'll get going. All right, we're going to start with the condo offer. So there are quite additional number of additional pages to the condo offer to purchase. So there's only a few sections that are different or added on to, I should say. So we'll start on page 1. So there's a section that addresses storage, parking, and fees. So I am just going to go through these line by line. If there is a storage unit, it asks to identify what that storage unit is. So line 43, storage unit is or is not included in the purchase price. So you'll strike 1. And then it asks you to name the storage unit number. And I used a real life example, actually a condo listing that I have right now, to show how these get filled out. So line 44, parking, the parking for the unit is, and then here you're going to identify the type of parking. So right in this example, I've got 2 specific spaces, one indoor, one outdoor, both are named. Sometimes this will just read the parking for the unit is a 2-car attached garage or 2 parking spaces. So you'll just write out and identify how the parking situation is set up. And then there's a space here for parking fees. So there is a parking fee, you'll name it here. Line 45, you're going to name what the association fee is. The association fee for the property is, and then identify the amount per month. Rarely there are association fees that are yearly. So if it's yearly, you would say, $1,200 per year in that space. The unit transfer fee. So this you're not going to know right off the bat. You'd have to learn this from the condo association. So unit transfer fee, buyer is aware the property may be subject to a one-time fee resulting from the transfer of the property. Any fees resulting from transfer of the property shall be paid at closing by, and then you're going to strike either buyer or seller. If nothing is stricken, it defaults to buyer is going to pay that one-time unit transfer fee. I would say this isn't too common, but there are definitely associations out there who charge this transfer fee. And usually this becomes a point of contention because it's only discovered on the closing statement after the title company gets in touch with the condo association to get their information. So I've definitely been a part of agents who've come to me to say who pays for this now that we know about it. So we'll always have to refer back to the contract, but yeah, that would be a question I would ask if at your listing appointments, if you know of a transfer fee that might be levied. I've seen them be pretty high, like $1,000 before. So line 49, note the association may charge fees at or subsequent to closing, which may association reserves, administration or other fee. Buyers advised to review the condo disclosure materials, including but not limited to current financial disclosure statements and other condo materials described. So this is just a warning to the buyer, making them aware that charges may apply. A lot of these times, these charges would come up in meeting minutes. If the seller is aware of anything that might be coming up, they certainly need to disclose that. But basically they're just a CYA for the condo associations and for the listing agent and for the seller, to say to the buyer, something might come up that we're just not aware of. And so the buyer needs to be aware of that. I think that's rare, but again, just a warning to the buyer. All right, that's all on page 1. Then on page 2 to 3, we get into the condo disclosure materials. So if you've ever bought or sold a condo, those are those, large packets of materials that that includes the bylaws and the rules for the association. These are developed by condo associations and their attorneys, and need to be provided to buyers at the time of the sale, at the time of an accepted offer, or within a certain amount of days. So I'll just go ahead and read it. Starting at line 107. So this is beginning on page 2, at the bottom of page 2. So seller agrees to deliver to the buyer within 10 days after acceptance of the offer, current and accurate copies of the condo disclosure materials required by Wisconsin Statute 703. The condominium disclosure materials include a copy of the following and any amendments to any of these. So these are going to be the set of condo materials that all associations should have. So we've got proposed or existing declaration, bylaws, and any rules or regulations, and an index of the contents. Proposed or existing articles of incorporation of the association. Existing management contract, employment contract, or other contract affecting the use, maintenance, or access of all or part of the condo. Move this. Then moving on to page 3. Line 115, projected annual operating budget for the condo, including reasonable details concerning the estimated monthly payments by the purchaser for assessments and any other monthly charges. Leases to which unit owners or the association will be a party. General description of any contemplated an expansion of the condo. Unit floor plans and maps. And the executive summary. So if any of these exist, they need to be passed along to the buyer within 10 days. Once that 10 days, or once they are provided, then we're going to get into the buyer's rescission rights, which I will get to in just a second. Sorry, I'm going to move this screen all around as I read these. Before I get into buyer rescission rights, there's just a note here on the conversion condominiums. So sometimes you'll run into condominiums that were converted from an apartment building. So if that was the case, if the condominium was an occupied structure prior to the recording of the condo declaration, it is considered a conversion condominium. And the condominium disclosure materials for a conversion condominium with 5 or more units also include. So this is just going to go on to state other materials that you should be on the lookout for if this is the nature of the condo, if it's this conversion condo that is described here. So the declaration statement based on an independent engineer's or architect's report describing the present condition of structural, mechanical, and electrical installs, a statement of the useful life of the items covered in line 1, unless a statement that no representations are being made is provided, and 3, a list of notices of uncured code or other municipal violations, including an estimate of the cost of curing the violations. What I'm going to say here is if this is the nature of the condominium that you are buying or selling, just come see us if there are questions. I think my takeaway for you here would just be, if this is the nature of the condo that you're selling, just to know that there's extra things that we need to be on the lookout for, that we need to provide. Okay, so getting into buyer rescission rights. So seller, as a part of this offer, is going to provide those materials to the buyer if they haven't already, via MLS. And they've got that 10 days to do it. So within that 10-day time frame, they're going to pass along those condo documents and bylaws, etc., to the buyer. So now the buyer
I have a quick question.
Yes.
So say, like, say some documents are in the MLS, but you get an accepted offer, would you expect the listing agent to then like also email them or just be like, hey, PS, or like, is that like, is like them
It's-
being on the MLS like an appropriate like way to deliver them?
So I think we've gone over that, like Joni discovered recently that that could be considered as delivered.
Okay.
And I think that is really, I guess, really muddy and really unclear. I think there's, breeds a lot of confusion. So I, as a listing agent, even though they are provided to via MLS, so for example, I've got I think 99% of the documents that are required in MLS right now. Once I have an accepted offer, I am going to resend them to the buyer's agent for
With
sure.
a receipt, that we have the buyers send a receipt that they've received.
Yes. Yep. Another thing that you could do, or as a listing agent may require, is acknowledgement that that the buyer has received them in the offer to purchase.
Right.
So you have that timestamp. So,
Good question.
yeah, really good question. So these buyer rescission rights. So this is a big deal. So buyer may we've got another chat question. Let me just, the condo, is that something we would ask? And what if the owner doesn't know? You could, that's definitely, Leah, something that is odd. And, at listing appointments, as you're going through and talking about the nature of the condo, that would probably come up. But I mean, short answer is, if you want to ask the question, I think it's something that you would know though, or that would definitely be something that would be shared with you at a listing appointment. So let me think about how you even ask that. It's so few and far between that I don't want it to be something that now I'm spending too much time on this.
Okay, so it's not common, so it may not come up, but just know that that's a possibility.
Yes.
Right.
Yes. So
You just ask the question if you're not sure.
yeah.
I mean, you ask from the association or the seller or whatever.
But it's such a big process going from a conversion of a apartment to a condo, that it would definitely be on everyone's on the seller's radar. It should be. So
The trend today is they're taking condos and making them into apartments.
that's more common today.
Right.
Yeah. So okay, I'm gonna keep going. Okay, I'm gonna start over again. 131. So buyer may, within 5 business days after receipt of all the required disclosure documents or following notice of any material changes in the required disclosure documents, rescind this offer by written notice delivered to the seller. If the disclosure materials are delivered to buyer and buyer does not receive all of the disclosure documents, buyer may, within 5 business days after buyer's receipt of the disclosure materials, either rescind the offer or request any missing documents. So from there, if the buyer does request any missing documents, the seller has 5 business days after receipt of buyer's request for missing documents to deliver the requested documents. Buyer may rescind the sale within 5 days after the earlier of buyer's receipt of requested missing documents or the deadline for the seller's delivery of the documents. Any document delivered to buyer may not be changed or amended following delivery if the change or amendment would materially affect the rights of the buyer without first obtaining approval of the buyer. Copy of any such amendments shall be delivered promptly to the buyer. The basic, the crux of this is that, and this is a huge buyer protection, that the buyer, it doesn't matter what they find in the condo materials and the disclosure materials and the bylaws, if the buyer wants to rescind the offer within this period, they have the opportunity to do so. So it's really important as a listing agent to get this condo, this receipt, the buyer's receipt of condo disclosure materials, so that that 5 business days kicks in. And we're keeping on top of that deadline. Once that 5 business days comes and goes and the buyer does not object to anything written into these condo disclosure materials, then we're just moving forward out with the contract. As a buyer's agent, you want to be mindful of the day as well. You know, if there's something that the buyer has an objection to, they need to get it a notice in. We need to get a notice into that listing agent within this 5 business days. So very important. You're going to include this deadline in your, you know, in your dates and deadlines correspondence with the parties of the transaction, making sure that this is on your calendar. Once you do, as a buyer's agent, receive those condo disclosure materials, and then as a listing agent, once you deliver them and get that condo receipt back, you're going to make note of when that 5 business days is up. So any questions about this?
I think an important point on this is the buyer receives the documents and the buyer realizes that something's missing. They don't send the receipt of the documents. They send a
Notice requesting.
notice saying what they're missing. And then they have an additional 5 business days to get that. And that's where we've had a lot of confusion, and the buyer will say, well, I didn't get everything. I didn't get all the materials. So now I'm going to rescind my offer. But the buyer never said that they never got everything.
Mm-hmm.
And that's a sticking point that's pretty important.
Line 141, parties agree that 5 business days begin upon the earlier of buyer's actual receipt of the disclosure materials, requested missing documents or material changes, or upon the deadline for seller's delivery of the disclosure materials or the requested missing document. Note, buyers should read all documents carefully. Licensees may provide a general explanation of the documents, but are prohibited by law from giving legal advice or opinions on it. So that's important to note as well, to communicate to buyers if they have questions on anything. Okay, moving this up. In addition to the review of the disclosure materials required to be provided, a buyer may wish to consider reviewing other condo materials as they may be available. So that's where we're going to get into our next contingency, which is new to the condo offer to purchase. But if the buyer requests, they can request additional condo information beyond what is in the condo disclosure material provision and make this a contingency. So a contingency for additional condominium information. Again, this is new to the condo offer to purchase. So this offer is contingent upon seller delivering to buyer at seller's expense. That's important. Sometimes these costs sellers money to provide, getting copies from the association. Within 10 days after acceptance of this offer, the information listed below that exists as of the date on line 1 of this offer. So, so beyond what I've already stated, we can make it contingent upon the offer to request and to review condo association's financial statements for the last 2 years, the minutes of the last 3 unit owners meetings, the minutes of condominium board meetings during the 12 months prior to acceptance of this offer, information about contemplated or pending condo special assessments, the association's certificate of insurance, a statement from the association indicating the balance of reserve accounts controlled by the association, any common element inspection reports. So if you are in those more sophisticated associations that have those swimming pools, just a ton of amenities, I'm thinking of Landmark on the Lake, for example, You can request inspection reports on those miscellaneous amenities. Information regarding any pending litigation involving the association, the declaration, bylaws, budget, and or most recent financial statement of any master association or additional association that this unit may be a part of, or other. Note, because not all of the listed materials may exist or be available from the condo association, the seller may wish to verify availability prior to acceptance of this offer. So as a listing agent, if you are receiving an offer that has this contingency for additional condominium information, we need to verify, for example, that any common element inspection reports even exist, right? If they don't, then we would want to consider countering that out. Or information regarding any pending litigation involving the association. So if you know that doesn't exist, then we're going to want to amend or counter that out as a part of the offer. So just like the condo disclosure material provision, the contingency, the buyer has the same rescission rights as it relates to these additional materials. So buyer may, within 5 business days after receipt of all listed materials, rescind this offer by written notice. If the materials are delivered to the buyer and the buyer does not receive all of them listed materials, the buyer may, within 5 days after receipt of the materials, either rescind the offer or request any missing materials. And again, seller has 5 business days after the receipt of the buyer's request to deliver the requested materials. And then the buyer may rescind the sale within 5 days after the earlier of the buyer's receipt of requested missing materials or the deadline for the seller's delivery of the materials. Again, same notes apply. Parties agree that 5 business days upon the earlier of buyer's actual receipt of the listed materials or requested missing materials, or 2, upon the deadline of seller's delivery of the listed materials or requested missing materials. So the point is that the buyer has rescission rights based off of these condo disclosure materials, and they have 5 business days to do it. And again, I think a point here too that I want to stress is that it doesn't matter what it is listed that the buyer objects to. All they need to communicate to the seller is that they object to the condo disclosure materials, offer is rescinded, and leave it at that. And that's all that needs to be communicated. Any questions about this?
Yeah, so I assume say you have a buyer who only wants the minutes of the last 3 meetings, so then you would include the contingency but strike out all the other things, or?
As a buyer's agent, right? Yep.
Yeah, right.
Could strike the rest of it.
And then as you said, we're about either amending or countering the things out if they don't exist. So would that the language in that amendment just be with delivery of A, B, and C, and then but X, Y, Z don't exist?
I would probably just refer to the lines and just say 154 to 161 are hereby stricken.
Oh, okay.
And just strike them versus making it.
So as a counter or whatever. But so then if you're amending it.
Same, I would say,
okay.
Yep.
Okay.
These are stricken from the offer to purchase.
Okay, and Steph, this is Jean. I came in a little late, sorry. I just want to confirm that if we are going to amend this, it's an amendment. If we're going to put them on notice that they're rescinding, then it's a notice, right?
Right.
Okay.
So if you're changing the terms of the offer, buyer and seller need to agree on that, and that would be on an amendment. That would be the tool that you use.
Right.
Notice of buyer's objection to the disclosure materials would go on a notice. Yep.
Got it. Okay. And is that all that's required, or is there a camera as well?
You would send the cancellation agreement along with that. Yeah.
Okay.
Yep.
So both would be required. Okay.
Yes. Yep.
Yeah, and to repeat what Steph said, you don't have to give a reason. You don't have to cite what it was they objected to. They're just objecting to the documents.
Okay. And this is just specific to condominiums.
Right.
Yeah, it doesn't apply to subdivisions that also have. Could
Good,
have.
good point, yeah. So, yep, this is the unique to condo associations. Okay, I'm gonna move on. Now we're gonna get into definitions, and I think I will go over all of these. Time do we have? Yeah, we've got time. I'm gonna go over these definitions that again are just unique to condo offers. And so here we go. Association. Move my Zoom screen here for a second, excuse me. Starting on line 176, an association provides, association means all of the condominium unit owners acting as a group, either through a non-stock corporation or a unincorporated association in accordance with its bylaws and declaration. The association is the entity that the unit owners typically use to act together as a group to manage and maintain the condominium property and finances. Every unit owner is automatically a member of the association, which adopts budgets and sets the amounts of the fees or the assessments paid by the unit owners. An additional association refers to any community, neighborhood, subdivision, master, or umbrella association with the power to levy fees or assessments on the property owner. I've never run into an association that has two governing bodies, but it must exist. Common elements. Common element means all of a condominium except its units. In a typical residential condominium project, the common elements may include the land, structural, and common parts of the building. So any entranceways, halls, elevator, meeting room, landscaping, roads, any outside parking areas, outdoor lighting, any recreational facilities, and all other common areas and amenities. The common elements are owned collectively by all the unit owners. For example, in a condominium with 100 units, each unit owner may own a 1% interest in all common elements. Thus, the unit owner would own an undivided 1% interest in the tennis courts, roads, parking lot, etc. So when you see, for example, like condo fees cover the maintenance of all the common elements and insurance for the common elements, that's what they mean. So just the elements of the building that are shared by all of the unit owners. Condominium is defined. Condominium means a property subject to a condominium declaration established under this chapter. So condominium is a part of an association. That is what makes it unique. So you will find rarely, for example, that there are single family condominiums. So there are associations out there that that include single family type houses, but are actually a condominium in nature and structure. Declaration. Declaration means the instrument by which a property becomes subject to this chapter, and that declaration as amended from time to time. The declaration is a written document that creates a condominium from one or more parcels of real estate. The owner declares his or her property to be a condominium. The declaration divides the unit into units, which are individually owned, and the common elements, which are owned in common by all of the unit owners together. One thing that was common kind of during that condo boom where people were taking their duplexes and making them into condominiums. So that would be one of the first steps, is getting it declared as a condominium and using that instrument. And then selling them as individual units versus the entire property as one duplex. Limited common elements. A limited common element means a common element identified in a declaration or on a condominium plat is reserved for the exclusive use of one or more, but less than all of the unit owners. A unit owner does not own a limited common element except for the percentage interest in the common elements, but is the only one who may use it, either alone or with others. This exclusive use may be subject to restrictions stated in the declaration or the condominium rules. Limited common elements may include a storage area, patio, balcony, garage, parking space, or a boat slip. Okay. Having those examples written in there is helpful.
Hey, Steph, just a quick question. Your example before about duplexes being broken out and declared as condominiums,
Mhm.
is that still something that is allowed today? Like, is
Sure.
that common practice? Okay.
I don't know how common it is, but I mean, it's definitely a prerogative of the unit owner of the duplex to divide
Okay.
it up. Yeah.
Okay. And just off the topic, is there like a reason why they would want to do that? Like from a tax advantage standpoint, or what is the benefit of doing that other than being able to just sell them separately?
Sell them separately, and I think potentially making more money than versus,
Got it.
yeah.
Selling them as one. Okay.
Yep.
All right. Well, that's a good thing. I never even
Yeah.
thought of that. I never even heard of it.
I'll just make a comment though that, kind of selling those, I think they're harder to sell than traditional condo associations, than condos that are part of a traditional association. They're just not, I guess it all depends on the buyer. I don't want to get into a rabbit hole. I was just going to say that they're, not managed as well. But then on the flip side, that might be appealing to somebody, if there's more freedom that comes along with owning one of those units. So,
Yeah, I get it. And maybe
Yeah.
lower HOA fees and all that.
right. Or zero HOA fees. That's-
Exactly.
Yeah.
Okay, thank you.
Yeah. Okay, so continuing on, I think there's just a couple more definitions here. So a small condominium means a condominium with no more than 12 units. Small condominiums are subject to all provisions in the Wisconsin statute, including the provisions for disclosure of materials, unless optional provisions for a simplified condominium are adopted in the declaration for the small condominium. I thought they were going to say, the only thing that I know that's unique to small condominiums is the requirement for the executive summary. Executive summaries are not required for condo associations that are under 12 units. So just kind of keep that in mind if you are selling something that's in a smaller unit and you're looking for that executive summary. And I'll show you what an example of an executive summary at the end of this training. Again, they're not required for smaller associations. So unit means a part of a condominium intended for any type of independent use, including one or more cubicles of air at one or more levels of space, or one or more rooms or enclosed spaces located on one or more floors or parts thereof in a building. A unit may include two or more non-contiguous areas. The unit owner is entitled to exclusive ownership and possession of his or her unit. A unit is not necessarily limited to an apartment-like concept and may also be a freestanding house, as I had described before, that there are some single-family condos. A structure plus surrounding land or land similar to a lot. Units may also include a separate area that is some distance away from the basic individual dwelling area. For example, a unit may be defined to include a storage area, patio, garage space, or a boat slip. What is included in a given unit depends on how the term unit is defined in the condominium declaration and plat. So kind of a long-winded definition. Okay. I think that should be it for the condo offer to purchase. So again, we've got our basic shell of an offer to purchase, our standard provisions, our standard, inspection contingency, financing contingency, appraisal contingency, and then these are the provisions and additional contingencies that are unique to a condo offer to purchase. So, a condo listing contract, again, same shell as our typical residential listing contract, except there are additional pieces that need to be filled out. So the limited common elements assigned to the unit include, so this is where you would list those things. So you could say, your patio, your parking space, etc. here. Storage, a storage unit is or is not included in the list price, and then you're gonna name the storage unit number depending on if it is included or not. Parking, the parking is, and then you're gonna describe the nature of the parking. So just like in our last example, I would have said the parking is one assigned indoor space number blank plus one assigned outdoor space. It could read the parking is an attached two-car garage. The parking is one outdoor space. The parking is none. There is no parking. You'll run into that too. But basically, again, you're just describing exactly how the parking is set up. Line 24, the association fee for the property is blank per blank. So it's $100 per month, or if it's a yearly association fee, you'll mark that as well. The right of first refusal. So the condominium association does or does not have a right of first refusal on the property. So you're going to ask this question. And if the unit owner doesn't know, then I would be getting in touch with the condominium association. Generally, condo associations do not have a right of first refusal. But what that means is if it does have the right of first refusal, if you do receive an offer on a property on the condo, you must take that offer to the condo association, and if they can or desire to have the wish of meeting the terms of that offer, they can proceed and buy that unit themselves, and therefore bumping that other buyer. So it's rare. I think that the one, if I remember correctly, and Joni, you might know, but the co-op on Prospect, I think, has a right of first refusal. That's the only association that I've ever heard of having that.
Yeah, there were too many legal claims against right of first refusal because of fair housing. And it was,
Okay.
and after that, it was a big wave of lawsuits and all of that. And after that, most condominium associations dropped their use of the right of first refusal.
Okay. Interesting. Glad I asked that. Okay. Then now here's the communication to the seller as it relates to the condo disclosure materials. So this doesn't get into buyer rescission rights because that's in the offer to purchase, but this is, setting the seller up for the condo disclosure material provision, letting them know that the seller agrees to provide the buyers with complete, current, and accurate copies of the condo disclosure materials. Seller is required to provide buyers with the condo disclosure materials within 10 days of acceptance, but no later than 15 days prior to closing. Seller is responsible at seller's expense to obtain all required condo disclosure materials and condo documents, which may be requested by a buyer in the terms of an offer, and to obtain and promptly provide the buyer with any amendments or updates to the condo disclosure materials arising before closing. The condo disclosure materials required by statute include a copy of the following and any amendments to any of these. So this is just outlining what I've already read in the offer to purchase. So this is just communication to the seller at the time of the listing that we're going to have to get these condo disclosure materials prepared for the buyer. So again, it doesn't state the buyer's rescission rights, but it does mimic the verbiage around needing to provide it within the 10 days of acceptance. Okay.
One point I want to make, it should be the seller's responsibility to get a new documents from the association instead of handing over their own copy or making a copy of their original documents. Because of the changes and amendments that are in, you want to get the most current version of all the condominium disclosure materials.
Mm-hmm. Yeah, there's so many times that people just recycle all of these and don't don't do their due diligence and yeah.
So let me ask you a quick question on that. Oftentimes the home association will charge a fee for putting the documents on a jump drive or sending them you know,
Yep. Just-
like hard copy or whatever. Who pays for that typically?
It's a seller. Seller is responsible at seller's expense on line 220. So the seller has to pay for that.
Okay.
The cost of selling and the cost of owning. So
Okay. All right.
yeah, good question. All right. Oh, it does get into the I take back what I just said. It does get into the rescission rights and in the listing contract. Okay, so the condo conversion elements are here as well. But then, yeah, line 246 to 254 goes on to describe the rescission rights. So, regardless, at listing appointments, we are, kind of describing how an offer is going to go as well to our sellers. So, setting them up, preparing them, giving them the expectation of this rescission right provision in an offer would be a conversation that you would be having with the seller at the time of listing. So, okay, so we're done with the extra provisions of the condo listing contract. Now I wanted to show you guys just examples of the bylaws and miscellaneous forms that are required because it is a condo. So first up, it's the condo addendum to the record. So I'm gonna stop my share. Actually, I'm just gonna get out of. Okay, can everyone still see my Chrome browser and my many tabs open? Okay. We're gonna go to the condo addendum to the real estate condition report. So this is required for all condominiums. This is attached to the real estate condition report. So as a listing agent, you're gonna have this filled out along with the record. And this just includes, and basically this was created, I believe, in response to like when the addendum A was revised to include like spaces for information that other parties to the transaction needed. So like title companies were having a hard time hunting this information down, lenders, etc. So they just created the space to put all of this information in one spot. So really, it's just describing that this is attached to the real estate condition report, dated, and then you would just mimic the date on the real estate condition report, the date, the condo identification and seller contact information. So the name of the association, the unit number, contact information for the unit owner or the listing broker. So as a listing agent, you're going to put your information here. The condo association information, information for the management company. If there is one, if there's no management company, then it would just be the association contact named within your association. So, there might be just a kind of a point of contact for miscellaneous questions identified as a part of the association. Condo line 227, condominium assessments, fees and charges. So unit owner is responsible for the following condo assessments, special assessments, and other charges if they apply. So this is just a space for you to name those here. They also have the question, have all current charges been paid, yes or no? And then executive summary. So a copy of the executive summary is attached unless this is a small condominium. So again, any of those associations that are less than 12 units. I'll show you an example of that. And then it just goes into residential condominium concepts. So those concepts that I defined earlier, common elements, limited common elements. I'm not going to reread through those, but that's the back page of the condo addendum to the record. Then I just wanted to show an example of condominium bylaws and rules and regulations. So this is the executive summary. The purpose of the executive summary is basically to summarize what the most typically, like, it's kind of the FAQ, the most commonly asked questions as it relates to a condo association. So the condominium name, how is the condominium association managed, parking arrangements. So this is basically just summarizing the rules and regulations and then putting it all on just one form. So yeah, again, people mostly want to know about parking. They mostly want to know about pets. So there's a question on pets here. May I have any pets at this condominium? Yes or no, what kind of pets are allowed? Major restrictions and limitations on pets. So yes, pets are allowed, but that, you know, leads into type, weight, height, number of pets. So that can all be described here. Another common question is the ability to rent a condominium unit. So there are a lot of investors out there who are just buying condominium units to rent out. In this example, these units may be rented, but the lease must be first approved by the association. Does the condominium have any special amenities and features? So you could describe all of the different amenities that might be a part of the association. So a common swimming pool, a clubhouse, an exercise room.
Hey, Steph, can I just interrupt you for 1 second?
Yeah.
Back to the pet area.
Mm-hmm.
When I was first getting started, I had a buyer who was interested in a condominium, and it was a building, like each building had 4 condominium units in it. And she was a pet owner. She had a dog. And what we found out, like it was very misleading. It said pets were allowed. But then we found out that there was only 1 dog per building allowed, which was
Wow.
really strange. So I just want to like flag that for everybody, that like you really got to make sure you understand and ask the questions about not just size of the pet, you know, specifically dogs and number, but does it pertain to 1 per unit, 2 per unit, or is it by building, et cetera? Because that really threw us, and she ended up not buying it because of that.
No, thank you for sharing that. I mean, it's all of these associations are so different from one another. So you know, there are agents out there who specialize in condo associations and are really familiar with all of the different condo associations that are out there. And just like knowing these kind of things like off the top of your head is good for, you know, if you're a condo buyer, you know, otherwise, you know, right now I'm working with a client who has 2 dogs. And it's a lot of work trying to find them the right association. So
yeah, and the other thing that we ended up doing is finding a loophole with an emotional support dog. So we got, in like a day, we got a letter from her veterinarian and her personal doctor stating that her dog was an emotional support pet.
okay.
So that was our way around that, but then
Yeah.
you know, there were other issues that came up and it ended up not working out.
Sure. That's the first I've ever heard of that though. 1 per pod versus a
Yeah.
unit itself.
Everybody share 1 dog.
Yeah. Yeah.
That could be a bonus.
Hey, limited ownership.
Your turn to walk.
The dog. Yeah. Okay, so but again, I'm not going to read through every single question, but basically it's just most commonly asked questions and are all put into this one spot on the executive summary. That being said, as a responsible buyer, that doesn't mean you're relying solely on this information. Once you receive the condo disclosure materials, you need to be the buyers need to be reading them through. So
one last question, Steph. Well, maybe not, but another question. My in-laws live in Pewaukee in a condo development, and the woman who's the president of the association charged $2,000 to the agent for the document preparation. That sounds illegal to me?
Yeah, that sounds outrageous. I mean, I would be pushing back on that if I were, I mean, I don't know where that would have been written down, or, you know.
Yeah, like I didn't know if that was normal practice. I had never heard of anything like that, but then again, and I'm not, in real estate that long, but
No, I mean, that's extraordinary. I've never heard of anything like that before.
okay, thank you.
So I would be questioning that up and down if
Yep.
I were somebody. Okay. Here's a balance sheet. An example of one. Now we're getting into the disclosure materials. So, there's a lot that goes into these. But here is the like table of contents, if you will, executive summary, the order in which these documents appear. So the declaration, the condo plat, articles of incorporation, the bylaws, the operating budget, and the management or employment contracts, and any leases. So you'll start to see that a lot of these look the same in structure. I mean, they do look the same in structure. A copy of the executive summary again. Did I just here we go. There's the declaration page. Getting into definitions and descriptions of units. I mean, I'm not going to go through all of these. I just wanted to show you an example and just have, give an understanding of the size and scope of these disclosure materials. It's just a lot of paper. So what I want to get into.
I would like to point out right here too, this isn't a place for you to help explain this to your buyer, if you're a buyer's agent. If they want somebody to review this for them and they don't understand it or something, they should have legal counsel. But you shouldn't be their counsel in explaining what all these things mean.
Yeah, and there is that warning right in the offer too, to help you. Wanted to get into, well, here's the condominium plat for this particular one. The articles. Oh, amendments. So long, same way an amendment works in our contracts, an amendment here is just changing what's been previously stated. Let me see if the end of this, here. Initial residential assessments. Oh, okay, so I think these were the initial HOA fees given when this was first developed. Here's the 2020 budget compared to the 2021 budget. Here are the rules and regulations. So this rules and regulations section, so the executive summary lifts a lot of this information from that. Revised rules and regulations. So yeah, again, we're looking at 115 pages here. So this is just, some are smaller than others, but they're generally very big documents. So I just wanted to show an example. Again, I'm gonna stop my share now. I want to ask if there are any questions or comments.
I have a question. So like a home that could potentially be on a sewer or a private well, is there an addendum that covers those types of inspections? I might have missed it in the beginning because I was late.
No, if they're, all of that is still covered under a addendum A. And a lot of that would fall under if the association is on a well, then it would likely be a shared well. So you would be asking for a shared well agreement. And that is a pre-printed provision in the addendum A. So if there is a shared well, I believe it's automatic that the shared well agreement has to be shared or given. So, but you would be mindful of those things. Yes, absolutely. That's still a part of the offer writing process when you're going through the document or having questions or going through the offer. And if you have a question about that.
So is it customary to use an addendum A for
Yes,
a condominium as well?
yes,
Okay.
yep,
And it's the same form, the same addendum A?
yes,
Okay.
yep. Thank you. That's a good question. Yeah, absolutely. Still use the addendum A.
And just on that note, because I'm in the situation right now and I was going to call you on it. If the seller's agent gets you back the information, gives you back the information from the report, like say the sewer, and there's a bunch of suggested repairs and prices that go along with that, that's all for the buyer to review and then the seller to cure, right? If we've given the seller the right to cure.
Yeah, I
And
mean,
how does that happen?
if you're working through a well, because you're talking about a sewer lateral right now, so that's
Oh, I'm talking about private septic, sorry.
a septic system.
Yeah.
Yeah, so if you're just gonna follow the language in the contract, but if it states basically that the seller has to provide a report stating that there are no issues with these systems. If there are issues with the systems, then they need to notify the buyer, and then I mean, I don't have it in front of me, but I think right to cure then kicks in, and if the buyer objects to the state of the septic system, for example, then they would communicate through a notice, and then the right to cure would kick in, and seller would have to determine whether or not they're going to cure those repairs or not. So
Okay, so this has to be handled with a notice back from the buyer to the seller.
if the seller is, we can talk offline about
Okay,
this,
let's
but
do that,
if basically if the seller delivers to buyer a report that includes issues that need to be fixed, and they're not communicating with them right off the bat that, yes, we will be handling these things prior to closing, then that's when the buyer's decision has to be made on whether or not they're going to object to it or not.
Got it. Okay, let's talk afterward. Thank you.
Sounds good. Okay. Any other questions, you guys? Thanks for coming.
Thank you for having it.
Group.
Good group. Yeah,
Thank
love
you.
this. Please come to our contract trainings.
Yeah, next
Thank you.
Monday, I'm going over the vacant land listing and the vacant land offer.
Yes,
Excellent.
that's going to be a good one.
Yeah, that's excellent. I know nothing about it.
Okay.
Thank you.
All right. Thanks, guys. Take
Thank you.
care.
Thank you.
Bye.
Bye.